Next up on This Week in Law, Eva Galperin and Nate Cardozo from EFF join me to talk about who can use and who can backdoor secure end-to-end encryption. If you don't care about that, you should. Don't miss today's episode.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is TWiL, This Week in Law with Denise, Howell, and Sarah Pearson. Episode 328, recorded November 20th, 2015. David L. Lightman's Encryption Solutions. This episode of This Week in Law is brought to you by Harry's. For guys who want a great shave experience for a fraction of what you're paying now, go to harrys.com. Get $5 off your first purchase by entering the code TWiL when you check out. And by FreshBooks, the super simple cloud accounting software that's giving thousands of freelancers and small businesses the tools to save time billing and get paid faster. Try it free at freshbooks.com/TWiL. Hi, folks. Denise Howell here, and you're joining us for This Week in Law. We have kind of a special edition of This Week in Law this week, 1 week after the attacks in Paris. We have two very wonderful folks joining us from the EFF. We're so glad they could make time to be with us today to talk about an issue that is all over the news in the wake of the Paris attacks. I'd like to introduce to you Eva Galperin. Eva is Global Policy Analyst at EFF. Hello, Eva. Wonderful to have you on the show. And joining us too is also from EFF, Nate Cardozo. He's a staff attorney on EFF's Digital Civil Liberties team. He also works on its Who Has Your Back and Coders' Rights projects. Hi, Nate.
Hey, how are you?
Doing well. I think you may be the first guest on our show in its lengthy history who was actually, I think this is probably the case, named after a Supreme Court justice.
You could say that, yeah. No relation.
No relation,
yes, I
but
am,
you share
I am
his
named after the justice.
Middle
I'm
and last
totally changing
name.
my name to Ruth Bader Ginsburg.
There you go. All right. Well, what we would like to talk about today is encryption and the state of policy and laws around strong encryption, particularly in the wake of last week's attacks. What you and Nate, Eva, had just posted before the attacks had happened, some good news from EFF that you had succeeded in having encryption classified not as a munition for trade purposes. Can we start off there and tell us about that?
Well, this wasn't specifically about encryption. This was about a situation in which the State Department was thinking about classifying what they called cyber munitions as actual munitions. And of course, the problem with that is that defining cyber munitions is nearly impossible. Defining sort of cyber surveillance, also very difficult. And so we basically filed some comments saying that the definitional problems are really intense, that the chances that you're going to get this right are very low, and you should just kind of stay away from this whole matter of trying to limit the exports of these things in this particular manner.
Right, and this kind of goes to the core of what EFF has done over the years, over its history. One of the early seminal things it worked on was having encryption not classified as a weapon. Isn't that right, Nate?
The case you're referring to is Bernstein versus United States, which was our boss, Cindy Cohen. It was her first case with EFF before she joined the staff. She was an outside attorney at that point. And the Bernstein case came about because now a rather famous professor of cryptography, but back then he was just a grad student at Berkeley, wanted to publish the source code of an encryption algorithm he had designed called Snuffle on the internet. And back then, encryption was classified as a munition. It was included in the United States munitions list and regulated under ITAR, which is the State Department's export regulation regime. And we sued on behalf of Dan Bernstein and won. And we got a case in the Ninth Circuit that stands for the proposition that code is speech and encryption is speech, and got encryption removed from the munitions list. It's still on what's called the EAR, which is the Commerce Department's regulations. But it's actually, those regulations are easy to comply with and very simple compared to ITAR, which is the State Department. So yeah, encryption has been an issue very near and dear to EFF for nearly all of the 25 years of our existence.
Okay, so what always seems to happen when there is global unrest and terrorism is law enforcement gets upset about the fact that there are communications technologies available for criminals and or terrorists to use that make it difficult or impossible for law enforcement to monitor the activities of those individuals. And we're seeing a lot of that in the wake of the attacks last week. Lawmakers in Washington are wringing their hands on the issue of encryption and surveillance. There is talk in Washington of postponing the expiration of, which would expire at the end of this month, mass surveillance of United States citizens in their communications. There's some talk of postponing that until 2017. And there is also talk of the importance of perhaps requiring technology companies who use end-to-end encryption on their devices and for their customers in providing some sort of required access to government, a backdoor for those technologies. So all of this is very much being discussed right now. And I'm wondering about, first, Nate, your take on the reactionary nature of those discussions. And then secondly, whether there is a path where any kind of backdoor to strong encryption makes good policy sense.
Sure. So I'll try and tackle. There were several questions in there, and I'll try and unpack them.
Okay.
The first is, encryption wasn't used in the Paris attacks. Sort of full stop. It simply was not used. As far as we can tell, the attackers were using plain old text messages, Facebook groups, face-to-face conversations. So seeing, NYPD Commissioner Bill Bratton, the director of the CIA, Director Brennan, immediately blame encryption and, somehow blame Snowden for the Paris attacks is, frankly, disgusting opportunism from our perspective. The pro-spying, anti-encryption agenda that the intelligence agencies and that law enforcement have really has nothing to do with what happened in Paris, because the attackers there didn't use it. So to see them try and use this horrible tragedy to advance their existing agendas is really the height of cynicism. So that's number one. Number two is the scientists, the mathematicians and cryptographers who have looked at the question are unanimous in their opinion that you can't build a secure backdoor like Director Brennan and FBI Director Comey are asking for. It cannot be done. The math doesn't work. And the FBI and the CIA and the NYPD can ask for it as many times as they want, but the answer is always going to be the same. No, it can't be done. So I don't know. I don't know how else we can say this, but it is not possible to keep us secure and give law enforcement a backdoor.
Okay. Hillary Clinton is hoping that it might be possible. She was speaking yesterday to a foreign policy group in New York, and her quote from there was we need to challenge our best minds in the private sector to work with our best minds in the public sector to develop solutions that will both keep us safe and protect our privacy. Nate, you just flat out don't think that's possible?
I mean, what is she going to do? Beat up the nerds and take their lunch money if they don't do what she says? Like, seriously, that's the argument. The argument is the nerds told me it can't be done. The nerds clearly aren't trying hard enough. But, you know, the mathematicians here are completely unanimous. There isn't, I mean, this is settled science even stronger than climate change at this point. In the climate change debate, you can find some quack somewhere who says it can be done, or who says, you know, that climate change isn't anthropogenic. But in the encryption debate, there isn't even that quack on the sidelines. It simply can't be done.
Well, I think that one of the ways in which to understand the way in which the government keeps insisting that that the problem really lies with the companies and the mathematicians, and not with law enforcement continuously asking for something which isn't possible, is that for mathematicians and for individuals and for companies, the possibility that that a backdoor is not secure and could be compromised by somebody else is an unacceptable risk, because it is a risk to all of their data, all of their personal data, all their user data, all of your data. To governments and law enforcement, the possibility that all of your data might accidentally be compromised by somebody else, they just don't care that much. They think it's a perfectly acceptable risk. And that is why you continue to see this sort of pressure, you know, oh, you're just not trying hard enough.
So one of the solutions that has been tossed out there, possible solutions that has been tossed out there, and that you guys have written about why it doesn't work at EFF, is this notion of escrowing an encryption key. Can you walk me through why that particular alternative, how that would work? First of all, is the user has the key, the service provider, we've been following whether Apple is going to concede to request to backdoor iMessage, for example. So let's use Apple. Apple doesn't have the key. The users have the key. In the escrowed key analysis, so would some secure third party, and let's put secure in quotes, and law enforcement would...
You already found the problem.
Yes. So with a proper warrant and good cause, law enforcement could get access to that key and decrypt the information. Expand, you've already started to tell me why that doesn't work, but please expand on that.
Eva, do you want to give it a shot?
Sure. No problem. Trusted third parties can't be trusted. They can all be compromised. Just because you've given the key to somebody else just means that that is going to be the attack vector. You haven't really solved the problem. You've just moved it somewhere else and then gone magic. And it simply does not work.
Right. Anything to add, Nate?
Sure. To add on top of that, there are some theoretically secure ways of doing this. You can do what's called split key encryption, which is a form of double key escrow, which in theory doesn't have a single point of failure. The problem is, and this was highlighted in a report by a group of cryptographers led by Howell of MIT, and including Bruce Schneier and Matt Green and Ron Rivest, who's the R in RSA. These are the sharpest minds in encryption. The problem is, even with a theoretically secure solution like split keys, implementations are order of magnitude more complex and therefore order of magnitude more likely to fail. We've seen even in secure, what we thought were secure communications programs like iMessage or CryptoCat, the math isn't what fails, it's the implementation. And in a split key encryption solution, the implementation is so much more complex and so much more difficult that in the minds of the cryptographers who have looked at the question, it's guaranteed to fail. And it's probably going to fail in a way that the bad guys, the Russians, Chinese, Iranians, Israelis, French, you name it, are going to discover much more quickly than Apple is going to discover. And that's going to leave us all hanging.
Yes, it will. Let's go back to a point you raised earlier, Nate, and that is that it's not clear at all. There is no evidence of what communication technologies the folks who planned the Paris attacks were using. There have been all kinds of rumors flying about. There have been reports of a secure messaging platform called Telegram. WhatsApp has been in the news, but again, no evidence that that's what they were using. Also, the PS4 has come up time and time again as a possible encrypted channel. So let's assume for a moment, though, that all of these communications were not taking place on an encrypted platform, even though ISIS appears to now have a help desk offering tips to its sympathizers and members as to how they can communicate securely. Let's assume for a moment that the Paris attacks were not carried out in that manner. Does it matter? I mean, particularly in light of the fact that ISIS is trying to ensure that people communicate in an encrypted and secure way. Shouldn't we just assume that they ultimately will, that we all ultimately will?
So I think what is safe to assume is that end-to-end secure communications technology exists and will continue to exist. That's just the world we live in. And nothing Congress, nothing John McCain, nothing Bill Bratton, nothing John Brennan, nothing Jim Comey, nothing any of them can do will ever change that fact. That's just the world we live in. The math is out there to make secure communications tools. ISIS has its own homegrown communications platform called Mujahideen Secrets, and I think they're on version 2.0 at this point. So yeah, we can make Apple backdoor iMessage, we can make Facebook backdoor WhatsApp, but that's not going to keep encryption out of the hands of anyone. All you have to do is go to the App Store and download a different application, and boom, you've circumvented the backdoor. So yeah, it is safe to assume we live in a world where people can use encrypted communications. It's not just a safe assumption, it's the baseline assumption that we all have to work from. Encryption exists and it's here to stay, and there's nothing anyone can do about that fact. We just need to learn to live with it.
So even though we talked about how encryption is not, and other cyber products, is not a munition, these arguments sound to me a lot like the gun control debate. And as I was noodling that this week, others were too. I saw that Hiawatha Bray wrote that up for Beta Boston, that the argument is similar. When having X item, here we're talking about encryption, is made illegal, then only criminals will have it, and that's not a good situation to be in. Is the EFF the NRA of encryption?
I would certainly hesitate to say that. I think that we do have some similar arguments in terms of how encryption works, but I think the biggest difference is that we have not even managed to demonstrate that encryption is a threat, that it's enabling terrorists, that it's some sort of problem. People who are advocating for gun control at least have an argument that there is a problem with shootings in the United States, and I think that's simply not true, as demonstrably untrue of encryption and terrorism in the case of the French attacks.
Yeah, I've been bothered by the analogy as I've been thinking about it all week. When a 3-year-old finds your encryption, it's not likely to go off in his or her face. So we're not exactly talking apples to apples here. But it has been interesting that there are some parallels to the arguments with both sides urging constitutional protection for their position, the NRA with the Second Amendment, you with the first for encryption. Are there
also
other... Also the fourth, that's what I was going to say. Tell me about the other constitutional bases for protecting strong encryption.
Well, definitely the Fourth Amendment. You have a constitutional right to privacy in the face of unreasonable search and seizure of your data. What is probably the biggest hit to the Fourth Amendment is the third-party doctrine, which states that if you are storing your personal data elsewhere, that it's not really yours. It belongs to the people whose computers it's on. And so most of us do not engage in the arcane art of running our own mail servers. Almost nobody does this anymore. And so your mail is not your mail. It is Google's mail, or it is Yahoo's mail, or your website is hosted at some ISP, and they control the website. And if the government would like the information about who's been visiting that website, or they would like the information about your email, they send their warrants and subpoenas, assuming they even send a warrant or a subpoena these days, directly to those organizations and not to you. And the biggest problem with that is that if you don't know that your data is being subpoenaed, you cannot hire an attorney in order to fight that subpoena if it's unreasonable. And you get this sort of secret grabbing of your data that we find very disturbing. But what's interesting is that the matter of data and your fundamental human rights is not just controlled by the Constitution. The Constitution is very powerful in the United States, but the UN also has a charter on human rights. And last year, the UN Special Rapporteur on privacy came out and said that encryption and anonymity are basic fundamental human rights that cannot be abridged, and that mass surveillance in and of itself is de facto a violation of that human right.
Right.
And to jump in
go ahead,
to jump in a little bit here, FBI Director Jim Comey repeats over and over again, to the point that news organizations have been taking this as truth, even though it's not. But he's repeating that the Fourth Amendment gives the FBI power somehow, and that with a warrant, the Fourth Amendment is a grant of authority to access our information. And of course, that's ridiculous. The Fourth Amendment is only a restriction on government power, and the warrant requirement is a warrant requirement. It is not a warrant authority. So the Constitution protects us from government surveillance, from unreasonable government surveillance without a warrant. It does not grant authority to the government to surveil us with a warrant. So the contrapositive is not true there. So I think we need to be careful when we listen to the counter argument from the FBI, from the CIA, from the NYPD, that that they have lawful authority, true, to search us with warrants, true, and that somehow that authority extends to forcing other people to decrypt our communications. That is absolutely false, and has no basis whatsoever in the Constitution.
So the distinction you're drawing there is that while there is constitutional protection from excessive surveillance, there is not likewise constitutional guarantee of surveillance. That the whole warrant and subpoena process emanates from other parts of our laws and is not one of these hallowed constitutional rights. Is that correct?
That's exactly right.
Yes.
Yeah.
Okay, we put these MCLE passphrases into our show from time to time so that people who are listening for continuing legal or other educational credit can demonstrate that they watched or listened. So I think our first one for this episode is going to be secret subpoenas. We'll put another one in before the end of the show. We're here with Eva Galperin and Nate Cardozo from EFF. We're going to get back into talking about how lawmakers are grappling with encryption and what they may or may not do to curtail your use of it or broaden government's ability to access encrypted data. Before we get to that, though, we're going to thank our first sponsor for this episode of This Week in Law, and that's Harry's. If you haven't heard yet, this month is Movember. There are a bunch of guys not shaving this month in support of research on men's major health issues. Harry's is the official partner of the Movember Foundation and will be donating money and helping raise awareness for men's health. So whether you are growing your beard or want an amazing shave, Harry's is a company you can feel good about. Harry's.com was started by two guys who are passionate about creating a better shaving experience by delivering an amazing shave at an affordable price directly to your door. The guys at Harry's not only deliver an amazing shave, but they also give 1% of their sales and 1% of their time back to the communities they serve. Harry's.com delivers a superior shave for an incredible price. Harry's bought a razor factory in Germany and has been crafting some of the world's highest quality blades for almost a century. Well, the factory has been. Harry's sells its products at factory direct prices, so they only cost a fraction of the price of big brands. Getting started with Harry's couldn't be easier. Over 1 million guys have made the switch to Harry's. Their website is streamlined and easy to use. It takes less than 30 seconds to place an order with great customer service and just an overall wonderful user experience. Now, it's not just for guys. I've been using Harry's for a while too. It was delivered right to my door. And you've got to see the great little kits that they provide you with. It comes in nice, easy to open packaging, always a plus. Nothing is confined in terribly restrictive plastic or anything else. You get a razor, you get blades, you get foaming shave gel, you get a protector for your razor so you can take it traveling. Here we go. The razors are really well crafted. They do not fall apart. They do not, I live in a very humid climate in Southern California. Well, not as humid as other places in the country, no doubt, but humid enough that other razors I've had have gotten kind of, scuzzy in the shower after a little while. That does not happen with a Harry's razor. It's made really well. It stays clean. It stays sharp. You get 3 razor blades and a choice of either shave cream or foaming shave gel in the kit. The starter Truman set is an amazing deal. With code TWiL, TWiL, you'll get all of this for just $10. Go to harrys.com and get $5 off your first purchase with the code TWiL, TWiL. That's Harrys, HARRYS.com, and enter TWiL at checkout. We thank Harrys for their support of This Week in Law. All right, getting back into our discussion with Eva Galperin and Nate Cardozo from EFF. In addition to being a week after the Paris attacks, we are right about a year after the Sony hack at this point. And I wanted to ask you guys, we've been talking about encryption and how it's not a good idea to outlaw it for policy purposes, simply to make sure that law enforcement can get to the information that it needs. Ron Wyden, a representative from Oregon, had the following to say on this topic. He says, requiring companies to weaken their technology when terrorists can fairly easily obtain advanced encryption technology products around the world doesn't make much sense to me. Would Sony have been amenable to being hacked in the way that it was if it had implemented the kinds of technologies that we're discussing today? Eva?
Well, I think that one thing that we've really seen come out of the Sony hack is an awareness of how little security Sony really had internally. And the biggest problem that Sony turned out to have was just a lack of separation between between the various parts of its organization and the data. So once you get in, you have pretty much everything. This is certainly not industry best practice. Anyone who has ever worked in IT was mortified when they took a look at the Sony hack. But I'm not sure that it is the role of the government to come in and tell people how they should be setting up their networks, how they should be setting up their encryption, what they should be doing in terms of privacy and security for their own companies. Certainly recommending best practices is a fine thing, but Sony clearly did not follow them. I think it turned out that Sony had something like 5 security people on staff for the entire organization, and most of them were managers. So this sounds like it was a very severe and sort of internal cultural problem.
Nate, do you think that the Sony hack is a good example for why companies and individuals need to have access to truly secure encryption, not encryption that can be broken or hacked if the quote-unquote secure third party holding a key, for example, is compromised?
So I think what the Sony hack is a good example of, like Eva said, is that information security is critical to our economy, to our human rights, and to pretty much every aspect of our daily lives at this point. Encryption is only one, frankly, small facet of information security, and Sony blew it on every possible front there was in terms of information security. But I think we can look at Sony, we can look at the OPM hack, we can look at the idiocy of the state of Georgia. Don't know if you guys are following that, but Georgia just released the name, driver's license number, social security number, address, date of birth, everything for every registered voter in the entire state. But anyway, we can look at those sorts of breaches as examples of how difficult InfoSec is and the consequences of getting it wrong. So when you hear Hillary Clinton, John McCain, Director Brennan, Director Comey ask for key escrows, split keys, companies to hold the keys, you name it, just remember that if a company or a government agency is holding something, it's going to get out. And the consequences of that in the encryption context are disastrous.
Yep, that's an excellent point, and I think we can look forward to hearing lots more about those things as the election cycle continues. We already heard from Hillary Clinton, and we're hearing from many other lawmakers pushing back on the technology companies in trying to find a way to compromise end-to-end encryption. Before we let you guys go, I know you have to run, and we don't want to keep you. We know that EFF does amazing work, and we don't want to keep you from getting that work done. We do want to find out about one of the great resources. This is our resource of the week that is available at EFF. It is called the Surveillance Self-Defense Project. Can you tell us about that, Eva?
Sure, no problem. Surveillance self-defense is available at ssd.eff.org, and this is our privacy and security advice for all kinds of people. So you see, we have sort of overviews and tutorials and briefings. We explain what kind of tools are out there and how to use them. But most importantly, we understand, and we're trying to make other people understand, that privacy and security are not tools, that they're a process. And so we have a lot of guides to understanding how to use this stuff, when it's appropriate to use it, what kind of information you want to protect, and who you want to protect it from, which is what we call threat modeling. Because honestly, just trying to protect all of your data from everybody all the time is impossible and exhausting and will drive you crazy. So we definitely recommend these resources for people who are trying to understand what it is they want to protect, who they want to protect it from, what they should do, what tools they should use, and what practices they should engage in order to do so.
What I love about SSD is exactly what you just said, Eva, the way it takes a practical approach and really breaks things down based on what your particular needs might be. There are different subjects by which you can dive into this. If you're a journalist on the move, there are things that you should look at. If you're an activist or protester, if you are a human rights defender, if you're an academic researcher, if you are LGBTQ youth, great resources tailored to those specific concerns. Anything else you want to add, Nate?
I would just point out that the SSD project is translated into a whole bunch of different languages at this point. I don't even know the complete list, but I know that one new language we just added was Amharic, which is the main language of Ethiopia, which is important to me because Eva and I represent an Ethiopian American whose computer was hacked by the Ethiopian government. So we're suing the government of Ethiopia over that in DC District Court. So getting SSD translated into Amharic along with Spanish and Arabic, and I don't even remember what other languages, was important to us, so that it's not just Americans who can protect themselves, but activists all around the world.
That's great. And my final question on SSD, I'm certainly a person who needs to pay more attention to safer online communications. I'm one of those, mass group of consumers that tends to just use the tools that are available out there without, sort of crossing fingers and hoping that companies are doing things like implementing HTTPS when appropriate, and that would be all the time. So, for the vast majority of us, having an easy route to being more secure is a great thing. And I take it that's what this is.
That's exactly right.
All right. Good. Thank you so much for joining us, Eva Galperin from EFF and Nate Cardozo as well. In addition to the great SSD project, EFF always has wonderful things going on. Is there anything else that you want to highlight for us before I let you go and wrap up the show?
Oh, HTTPS Everywhere.
Yes.
HTTPS Everywhere is a browser extension for your either Chrome or Firefox browser that makes sure that if you're going to a website, if it has HTTPS enabled, that you're using HTTPS by default. And that improves your security against sort of mass surveillance a great deal. There is also a mode for HTTPS Everywhere called HTTP Nowhere, which will not even let you go to sites that are being served over straight HTTP.
That's right. And Nate just put in IRC, the privacy badger. That's something I have running on my browser, and we've featured on the show before. You want to remind us what that is, Nate?
Sure. So Privacy Badger is based on code from an ad blocker, from an open source ad blocker, but it is itself not an ad blocker. Instead, it's a tracker blocker. So what it does is it doesn't have whitelists or blacklists. It identifies nefarious third-party tracking cookies and blocks them based on the observed behavior on your machine. So it has some intelligent learning, some machine learning technology built in, and it will recognize tracking cookies and block them. So the longer you use it, the better it gets.
All right, we'll go ahead and let you guys go. Thank you so much for joining us today.
Thank you.
This conversation will continue, and you've really helped us understand the importance of the policy considerations around encryption. So we greatly appreciate it.
Awesome. Thank you, Denise.
All right, take care.
Bye.
All right, folks, I'm going to go ahead and wrap up our show here. It's going to be obviously a short episode of This Week in Law. But we had to let the EFF staffers go do what EFF is so good at doing. So I'm glad that you could join us. I do have a tip of the week for you to go along with our resource of the week. That has to do with airplane boarding passes, which have been much in the news lately. There was somebody named Brian Krebs, a security blogger, who noticed that if you used any sort of barcode reader that's available online, you might get some information out of the barcode on your boarding pass. And I don't know about you guys, but I tend to not think of boarding passes as something that I need to shred after flying. It turns out that there is some information that's available in a boarding pass, but it's not much more information than you would get simply by looking at the pass. As Cash Hill wrote up at Fusion, to the extent there's any additional information in the barcode, she did some testing on her own. What you were able to get out of there is possibly the person's frequent flyer number. The boarding pass itself is going to have their name and the date of travel and possibly other information that you might care whether it falls into the wrong hands. So our tip of the week is twofold. Number one, think about the information that's on your boarding passes and whether you want it out and about in the world. And secondly, it seems like the best way to control that information is by using the I don't know whether you'd call it an online boarding pass or a mobile boarding pass, but the ones that are available for you to bring with you to the airport on your smartphone. Of course, then you have to worry about the security of your smartphone. So bear that in mind too. But once you have it on your smartphone, it's not on a piece of paper that someone can pick up and read and or scan. At least it's in presumably your control. We do have one other sponsor for this episode of This Week in Law that I'd love to thank and have you give your attention to, and that is FreshBooks. If you are a freelancer or run a small business, chances are your least favorite part is rummaging through receipts, trying to keep track of your expenses, creating, formatting, and sending invoices, and the worst, tracking down customers who don't pay you on time. FreshBooks is the super simple cloud accounting software that's giving thousands of businesses like yours the tools to save time billing and get paid faster. I use FreshBooks in my law practice, and it really keeps my law practice cranking along with just me at the helm. And that's the perfect use case for this tool. It helps you run lean, mean, and yet professional. Getting started on FreshBooks couldn't be easier. Even if you're not a numbers person, you'll be creating and sending invoices in minutes. Get paid up front. Now you can request a deposit in FreshBooks. No more covering costs out of pocket or waiting until the end of a project to get paid. You can organize your expenses easily. It's easy to track your time almost instantly, even on mobile devices. And with their automated late payment reminders, you can avoid those awkward emails to late paying clients. With FreshBooks Automated Customer Reviews Report, you can see all of your reviews in one place, then easily post them on your website. You'll wonder why you didn't start sooner. If you have questions, help is free forever, and you can always count on FreshBooks award-winning support rock stars to go above and beyond whenever you need a hand. Getting started is simple, and it's totally free for 30 days. Go to freshbooks.com/TWiL, and don't forget to enter This Week in Law in the How Did You Hear About Us section. Start your 30-day free trial today. Thank you so much, FreshBooks, for supporting this episode of This Week in Law. All right, and I think we'll make our second MCLE passphrase, privacy badger, don't care. So if you are interested in applying for MCLE credit for watching or listening to the show, we have more information for you on that. If you're a lawyer in the United States, head on over to wiki.twit.tv, find our This Week in Law page, and right there you'll find information that we have sort of a 50-state breakdown on how you can go about submitting for MCLE credit in your jurisdiction. We really appreciate your joining us for This Week in Law this week. Sarah is out. She will be back shortly. But we're glad you could join us. If you've done so at 11 o'clock or shortly thereafter on a Friday, you've joined us live. That's when we record the show. And that's 1900 UTC this time of year, if I'm not mistaken. So we love it when you join us live. You can jump into IRC, let us know what's on your mind. And it's always fun to have a live audience for the show. In fact, the live audience is one of the most fun parts of the show. But if you can't join us live, don't worry about it. You can go over to twit.tv/TWiL. All of our episodes are there going back 9 years at this point. So you can find our older episodes. You can sort of track the discussions of the issues that we've covered over the years and how they have developed over time. Encryption certainly being something that lawmakers bring up and are concerned about in the aftermath of events such as what we witnessed last week in Paris. So we hope you'll continue to pay attention to these issues. We hope you'll join us next week for This Week in Law. And until then, take care.